cross-examine based upon the...
Okay.
And Judge, based on that, I don't have any further questions of Trooper Kaiser at this time.
Cross-examine.
All right, Trooper Kaiser, I'm going to ask you some questions, and I'm going to try to be as direct as I can when I ask him, okay?
Yes, sir. Good morning.
I think that, good morning. I think when I've talked to you before, I've just asked that you, my questions are going to generally be tailored to, because we got a lot of ground to cover. I'm going to try to ask you questions that call for a yes or no answer. I understand you understand that?
I do
Okay.
understand.
If you have difficulty answering the question yes or no, just say, I can't answer it that way, and then I'll attempt to do a better job of reframing the question, okay?
Yes, sir.
And what I'm going to do is, Mr. Polanco, I put down a copy of the transcript. What I'm going to do is this as well. Can I approach, Your Honor?
Yes.
So I don't have to approach repeatedly. All right. This is a copy of the transcript from the preliminary examination where I already cross-examined you in Oak Park. You remember that proceeding?
Yes, sir.
Okay. Take that, just put it down, face down. If you need it, you'll have it here. This is an entire copy of your investigative file, your report from this case, as I understand it. I'm going to give you that as well. Just, if you need to refresh yourself, if you need to refresh your memory, just let me know, and then you'll have it right there, and we can save a little bit of time, okay?
Absolutely.
All right. You're a state trooper,
That's correct.
and this Michigan State Police has policies, correct?
Yes, sir.
Okay. And those policies are called official orders, are they not?
Some of them are, yes, sir.
And they're assigned numbers, correct?
Some of them are, that's correct.
For example, there could be an order number 1 or order number 5, right?
That's correct.
All right. Order number 87. Have you heard that number before?
Yes, I've heard 87 before.
Have you heard order number 87 before?
Not by number, I couldn't reference it.
Would you agree with me that, let me see if this language, if you've heard this before in your experience, okay? Let me back up one second. The Michigan State Police has policies about preserving and collecting evidence, true?
Yes, sir.
The evidence collected has to be collected, cataloged, or indexed, correct?
Correct.
Evidence can be photographed, correct?
It can be.
Okay. And let me ask you, the Michigan State Police has a policy that says certain procedures shall be followed in order to ensure that a proper record is maintained of all property or evidence. Is that true?
Yes, sir.
Okay. Your Honor, I don't think there's any objection by the people who have already to the admission of Defendant's Exhibit A, which is Official Order Michigan State Police Policy Order Number 87. So I would move at this time to have Defendant's Exhibit A admitted. Unless, it's okay. If I misunderstood the stipulation, that's fine. If I did, then I'll question about it.
No, I'll stipulate that document. I don't know if it's an official, I don't have personal knowledge that's an official order, but I stipulate the admission of that document, sure.
I'd not receive it.
Okay. And there's Defendant's Exhibit A. Now, you testified that, what policy number, we'll strike that, the Michigan State Police, you haven't produced, and tell me if I'm wrong, an actual written policy that says that in OWI or open intoxicant cases, that you should dump out the contents of the bottle and or not actually catalog or preserve the bottle. Is that true?
You're asking if I've produced a
Yes.
document?
Yes.
I have not produced a document.
Okay. Is there such a document?
I am not sure, to be honest.
How did you get the order to process open intoxicants by pouring it out and giving the container back?
Judge, it's my contention that there is no such order.
I'm just saying,
I understand.
I mean, obviously you don't see an order here, but how did you learn to do that, and who told you to do that?
Because order number 87 says that, and if I could just intercede, Judge, order number 87 says, if you look at the exhibit and you look at page 1 and page 2, it says the following procedures shall be followed in order to ensure that a proper record is maintained of all property. Evidence taken after 1/1/1999 shall be identified by attaching an exhibit label generated by the department's records management system. Not identified, and there's a sticker, obviously. And then evidence that received, transferred, removed, replaced, or disposed of the property segment shall be updated. Do you want to take a look at that policy to answer whether or not that's what that actually says? Trooper Kaiser?
Should I answer the judge's
Oh,
question?
we'll do that and then you can answer me.
Okay, yes, sir, Your Honor. Not all policies are contained within the official orders. They're general guidelines
Okay,
to operate by. There are local post policies, there are district policies, much the same way different courts of jurisdiction have different policies.
okay,
Not everything is contained in this.
okay.
There are local policies and agreements with prosecutors' offices, et cetera, that supplement these.
Okay.
All right, let me ask a question about that then. Trooper Kaiser. Let's start with this exhibit and then we'll get to the local agreements that you talked about. The Michigan State Police Policy Number, Order Number 87, says that is the, take a look at it, it's right next to you if you want.
Yes, sir.
That is the official policy that shall be followed in order to ensure that a proper record is maintained of all property or evidence. Is that true?
That is what this official order says, yes.
And it says that property or evidence taken after January 1, 1999 shall be identified by attaching an exhibit label generated by the department's records management system. Is that what that says?
If the property is taken, yes.
Okay. And I thought that you would say that. And then the next section says that evidence that's either received, transferred, removed, replaced, or disposed of. Want to take a look at that? It says that
No.
shall be preserved or collected in some fashion, right?
Yes, sir.
Okay.
I believe you use the word cataloged, which is what my report does. It catalogs that.
We'll get to it. Just if you and again, if you can't answer my question, then just let me know and I'll do a better job of rephrasing. Okay? You said that you've previously testified, as you have just now to the judge, that it's not our policy to place the bottle into evidence. Have you said that before?
Yes, sir.
Okay, so let me ask you this question. You told the judge that there are some local post policies about open intoxicant cases.
I
Okay.
told him there were local policies. I did not specifically state open intoxicants,
Okay.
but
Well, let's make it specific to the judge's question so we don't mislead the fact finder, okay? Would you share with me what post policy number says that in an open intoxicant case that the bottle should be dumped out and the bottle should not actually be placed into evidence or photographed? Tell me the policy number, and I'll FOIA it.
yes, sir. Not all policies have numbers. Some are memos, some are letters of understanding.
Tell me
Not
the memo.
everything has
Where's what? I just want to know if there's a policy.
Let me get to the point.
Yeah.
Okay, what was the legal state police policy, procedure, order, whatever?
Yes, sir.
That you followed in pouring out and not taking into custody the open intoxicant bottle,
Yes, sir. Since the day I came in the department,
which was
March 10th, 1996. As I said, I'm in my 15th year.
Right.
From that time forward, we have always disposed of the alcohol at the scene due to storage problems, fermenting, potential explosive situations with higher concentrations of alcohol. We don't store that in our property locker. Also, the sheer volume of the size of alcohol containers and liquids, etc., prohibit the prolonged storage of them in our property locker.
so no one has actually ever been arrested for open intoxicants because you'd have no evidence.
Yes, sir. It's cataloged in our report, and based on our training and experience, obviously, you know what alcohol smells like. I know what alcohol smells like. It's in a manufacturer's bottle claiming it to be alcohol.
Trooper, the judge is asking great questions, so I don't want to interrupt him, but let me.
Oh, that's fine. They.
Well, they're good questions, because the importance of the bottle, well, let me back up. the importance to the accused in a case is that he has the right to challenge or contest evidence later on in court. You understand that?
I do understand that.
In that the location of the bottle, for example, is an issue in an open intoxicant case, correct? It can be.
It can be.
In other words, was it in the trunk or was it in the interior passenger compartment of the car, right?
That would be
Okay.
a factor.
One way to actually preserve the location of the evidence would be to actually take a photograph of it, where you observed it, true?
That is one way, yes.
Okay. Another would be to bring over an eyewitness, for example. Could be some passerby, could even be another backup officer, true?
It could be, sure.
Another could be to actually have, to leave the evidence where you observed it, and when a tow operator comes, have the tow operator inventory the item where you observed it, true?
It is possible, yes.
Okay. In the Michigan State Police policy, order number 87, can we agree that that's the only written policy that you could produce that describes what to do with evidence of a crime? Can we agree with that?
Readily produce, yes.
But do you mean that if we took a break, for example, that you could show up here if the judge instructed you to in the afternoon or the next day with some policy that says you were taught that it's appropriate to dispose of either the contents of a bottle or a bottle itself that could be evidence in a case? Are you saying that you could produce that?
I don't know if I could, sir.
Okay. I'm going to assume until it's produced with the judge's permission that if you can't produce a list or something that says that, then it doesn't exist. Okay?
That's fine, sir.
So, policy number 87. There's no photograph that shows this alleged open bottle of liquor in the interior of the car, correct?
No, sir.
There's no photograph that shows the condition that the bottle was in, whether it was in the interior of the car, whether it was in the trunk, true?
There's no photograph of that. That's correct.
There's no photograph of whether the seal on the bottle was open or broken, correct?
There is no photograph of that.
There's no eyewitness. For example, this other backup officer you mentioned today, who we'll get to, she's not an eyewitness to the location of the bottle, is she?
I don't know.
Okay. Well, you said that she arrived after you'd already done everything. And is that true?
She arrived after Mr. Jordan was in custody.
Okay. Well, did you actually make any notations in your report where you said, I showed Trooper Millhouse where this bottle was located to have another witness corroborating that?
I don't believe so.
Would you tell Judge Sosnick whether Trooper Millhouse was even mentioned in your report?
Hold on a minute. Mr. Blanco, is the basis of you're not going to open intoxicants, you're going strictly on the basis of the fraudulent license?
Yes, that as well, Judge.
All right.
Because and I'll share with the court, our theory of the case has been known in it's my contention, Judge, and it's our contention that there was no open bottle of liquor in the vehicle. And my client, on top of that, we have another witness who will come.
But knowing that the arrest will fall or stand on whether or not the condition of the license, whatever, creates probable cause to arrest them, not.
I can go right to the license. And if we're going to move past the open intoxicant issue, I'll go right to the license issue. That's fine.
That too, Judge. I'm fine with that.
That's fine.
Okay, yeah. All right.
Okay.